Good morning, everyone. We'll just wait a few moments to see if there are any late arrivals. I guess we'll give one more minute time and then start off with our web. I guess we can start going then.
Yes.
Welcome to this autumn's first Growth Academy webinar. Today we'll be looking into NDAs and seeing what they're used for and how they're used for and what they entail within the actual agreement. So I'm Juuso Turtiainen, I'm an associate here at Lexia Attorneys, and with me today is Anni.
Hi everyone, my name is Anni Kaarento and I'm working as a legal trainee here in Lexia.
Awesome. So I guess we can straight away dive into it. Anni will be looking at the questions, so you can type your questions in the chat, then we can look into them either during or after the actual main portion of the webinar, and then we can have a Q&A at the end as well. All right, but to dive into non-disclosure agreements, so they're essentially made to govern confidentiality. This can be done either through the actual agreement or through NDA clauses, which are a part of the actual larger agreement. The NDAs themselves can be either, as said, a standalone agreement, or as part of the major agreement between two parties. They can be either mutual or one-way agreements or clauses, essentially depending on the flow of information. So if you are giving your information, confidential information, to another party in the course of analyzing whether to go ahead with a relationship, it is better to essentially take on a one-way NDA, whether agreement or clause, so that you have more control over what is done with the confidential information. But if both parties are sharing the information, even if there is a bit of an imbalance, a mutual NDA it should be utilized. So already a bit touching on the matter, but why use an NDA? Essentially, it is to be able to receive proprietary information. It is utilized to assess whether you want to go forward with a business relationship with the other party in question. For example, to test their technical information, test their software, discuss possibly a commercial cooperation. Maybe there's a merger or an acquisition in the works. You want to discuss some confidential matters with the other party. So, and the NDA is a good tool to utilize in the process of starting up a relationship with another party. So it is the first agreement to be put in place so that you can more freely discuss how you want to take the matter forward. As said, disclosing it provides the proprietary information. The NDA provides safety, so that you have at least a safety net with regards to actually having an agreement in place to govern the relationship and how to for what purpose the confidential information should be used, what confidential information should be shared, what is considered confidential information, and what happens, for example, when you terminate the agreement. It is a necessity for initiating the cooperation between any party. So without it, it is quite difficult to control how the other party will use whatever information you provide to them. And it can lead to disagreements and arguments in the future. And of course, there are other agreements and arrangements that can be done to ensure confidentiality, but it is process-wise, it is quite a good way to start the relationship. So here we're going into the basic content of an NDA, of course, setting out the parties who are party to the actual agreement itself, setting out the purpose of the NDA. So what is the confidential information that can be discussed under the NDA, what the information can be used for, so assessing or analyzing, for example, the software that could be discussed, the level of care, so what's the standard of care for the confidential information, how the other party should treat the confidential information you are providing. Then setting up certain exemptions to the confidentiality that will go into a bit more detail a bit later on. Then, of course, with regards to any contract, it is essential to set out the intellectual property rights and the protections, declarations of ownership and licenses and so forth with regards to any intellectual property rights that could be discussed or shared under the agreement. Then, of course, what happens if the relationship that's been formed by the agreement is terminated for any reason? So what happens to the material itself that has been shared? Will it be returned, destroyed, or what will the parties do with the materials? Also, something that's seldomly used, not very common, but could be put into the agreement if there is a necessity for it, is auditing rights. So to the right to ensure that the other party has actually complied with the terms of the NDA. This is a quite heavy term, but in the end, if you are sharing something that is extremely confidential, it may be useful to have the right to audit how the other party is working and set out that in the auditing rights clause. Of course, the term of the agreement, so how long will the agreement stay in effect once it's been signed? So is it for perpetuity or for a certain amount of years? And how long will the non-disclosure obligations, the confidentiality obligations, remain in force after the agreement terminates? So of course, if you're sharing something very confidential, it is advisable to ensure that the information that you're sharing will be kept confidential, even though the agreement terminates for a certain amount of time until the actual confidentiality regarding the information that's been shared becomes sort of obsolete. Of course, sanctions are essential in any NDA, so setting out what happens when or if the other party breaches the agreement, but also to set out the sanctions and rules regarding a breach from the perspective of yourself, so to ensure the process and what will happen if you were to breach the agreement. Then just the general clauses, the assignment and amendment. So what will happen? Can the agreement be assigned? Can it be amended? How it can be amended? The invalidity or unenforceability of the agreement should be set out. So in what cases, if the agreement is deemed to be invalid or unenforceable in a jurisdiction based on mandatory legislation, how that will affect the actual NDA itself. So will all of the clauses be deemed invalid and unenforceable, or should it just be the clause that is seen as invalid under the mandatory law? Then that should be replaced, or so forth. And finally, the dispute resolution process, as well as the governing law of the agreement, which then, of course, set out where, for example, the agreement will be resolved if there is a breach of the agreement for any reason. So diving into the actual purpose of the agreement, this is necessary to set out at the beginning and be very clear with the purpose, depending on what information is being shared and for what reason. The purpose is a definition of within the agreement, so it will be used throughout the agreement, and it has its impact on other clauses. So here it is viable, or it needs to be taken into account that the purpose is defined to cover any discussions that you might want to have with the other party. So whether it is to evaluate their technology or evaluate a business relationship or to evaluate possibly even a funding round or so forth, it should be set out to what purpose that information that you're providing to the other party or vice versa can be used and should be used. Unless it is more of an open discussion on how to go forward with the business relationship, then the purpose could be a bit broader, but it should be defined why the NDA is essentially needed and what the information under the NDA will be used for. And it is essential to protect your proprietary and confidential information. So when defining the purpose, you should keep in mind that you should not provide the information to the other party that's not covered by the NDA, or vice versa. You utilize the information received from a party for any other purpose than what's been set out in the actual agreement itself. So then going on to the definition of confidential information, what you need to think about is, does the definition of confidential information cover all the necessary matters? So where you're sharing something for the purpose of a business relationship with another party, that can be in a lot of different forum that you might want to discuss taking a joint venture forward. You might want to discuss creating a new software with the other party, or whether it's just analyzing whether their software could be something that you could be utilizing for your business. And in that sense, it is quite a good idea to cover this in the definition of confidential information itself. So often this includes anything from the specifications and documentation regarding the software itself, any presentations or commercial materials that you might bring out during the discussions, all the intellectual property rights that you might discuss, possibly ideas where you want to take the business forward, know-how that you might be presenting under the NDA to discuss the business relationship. So it is quite necessary to define the confidential information itself, and especially where you're talking about a larger business relationship, it may be a good idea to make the definition quite broad, but I'll talk about that in a second. So the other major matter to think about is how the confidential information itself will be provided. Is it all the oral discussions? Is it oral information, or is it written information, or can it be both? Of course, when it comes to any discussions, it's always a bit difficult to prove what sort of information has been discussed. Although if it is covered by the NDA, so any discussions that you may have, then you have those grounds if you can quantify it, that's something that the other party has breached the agreement and told forward what you've discussed under the NDA. Also, the balance between what is confidential information. Is it only information that's marked as confidential, or is it everything that's been discussed for the purpose involved? So where it is set out that it is only information that's marked, then you need to remember throughout the process to always mark everything that is confidential as confidential, so that you're not giving any information that should be kept confidential as just essentially public information. So in the case where you're looking at marked confidential information versus not marked, essentially all information being confidential, you need to be mindful of the information where it is only, i.e. marked confidential. Now, looking at the definition, it is often made quite broad to cover all possible disclosed information, but this in the end can lead to sort of issues where the parties aren't quite sure what is confidential information, and it can lead to a bit of discussions in the future, especially where the relationship hasn't gone forward and both parties go forward with their own businesses, but something that could be seen as confidential under the NDA comes forward in the future, and you have to have the discussion with the other party or internally whether this poses a risk as you've discussed something with the other party back in the past. So here it is where confidential information is made quite broad. The purpose for use should be clear within the NDA so that you have defined it within the agreement and it is covered by that agreement. So exceptions to confidentiality, these aren't, of course, the first thing that comes to mind, but there are situations where confidential information should be seen as not under the NDA. So, for example, in situations where information that's being shared is in the public domain, essentially that it's already been publicized, thus not covered by the NDA. Especially, it is good to define here that it hasn't come into the public domain by the other party essentially leaking the information to the public. But if it is already in the public domain, it should really not be covered under the NDA. Also, where the information was known to the receiving party before the actual business relationship or the NDA discussions have gone forward, these are often seen as exemptions. This, of course, it needs to be essentially quantified at that point where the other party becomes aware that information, that there is such information. And in that case, it is good to have written records of what information you are creating so that you can show the other party that, look, you've created it before any of these discussions and it's not a breach of the NDA, or vice versa, to ensure that the other party has written records of anything they create. Otherwise, there could be a risk that there would be a breach of the NDA itself. Also, where information is disclosed to the receiving party by a third party, this is quite straightforward. If a third party provides some information, it is hard to control what third parties provide. Hence, it is quite difficult to tie them to an NDA where they're not an actual party to the business relationship that you're discussing. But also, it is good to set out certain terms that this needs to be able to show, so the other party, the receiving party, should be able to show it either in writing or in another form that they've actually received it from a third party and that they haven't received it from a third party and exploited what information you shared with them under the NDA. Also, information that's been independently developed. So this is especially where a person has had no access to the information being discussed as confidential information under the NDA. So here, again, process-wise, it is essential to have written records of what you're creating, especially where it might be sort of close to what's being discussed under the NDA, to ensure that if something would come forward in the future, it is covered by the exemption in the NDA, so that you are not in a risk of breaching the NDA. And finally, mandatory disclosure. So here, the exemption is with regards to, for example, court authorities, a case ongoing, and information should be provided to the courts or another governmental authority. And in that sense, of course, it is something that should be exempted. But in any case, even in such a situation, you should set out in the terms that only information that is necessary to be provided to the authority or court should be provided, and the parties involved should essentially try and limit access to the information where it's not necessary to be provided, if possible. Then going forward to allowed and restricted usage of confidential information. So this is essentially under the purpose and why the purpose is extremely important to be defined. So here, with regards to the terms, it is where you're setting out what the usage and what is allowed and what is not. You should set out information that is only defined under the purpose may be used or for that purpose. So, for example, testing the software, testing the let's say, information that you've been provided. possibly interoperability with the other party's technology and product. So seeing how it works with your software or systems. For example, if you have a subcontractor, maybe you want the subcontractor to create something for you to see their talent and whether they are the right subcontractor for you. So here, you should define under the purpose what the information can be used for. And once the purpose has been completed, that it's no longer allowed to use the information that's been provided for any other reason. Also, it is essential to set out who is allowed to access, use, and test the information or see the information. So here, for example, the employees who are involved with the confidential information or the testing, that they are, for example, under NDA. So if you're providing the information, it is essential that you ensure that the other party complies with this, that the other party has to have NDAs in place with any employees or subcontractors or other advisors that may test or use the information provided, so that you have at least a certain level of control over the confidential information that you've provided for the other party, and vice versa, to know who you may provide the confidential information to for the purpose of the actual agreement. Here is another matter to note. Whether it's the NDA or within an agreement itself, there's often a mention of the right to reference or right to publicize, and this is often covered by sort of the confidentiality obligation. So where you have the right to inform the public about the relationship with the other party. So often this is something that needs to be set out so that there's no issue in the future where you've, for example, set out a very good relationship with a big operator in your field and you would like to showcase it. It is good to ensure that you have the right to showcase that relationship itself. So going on to protection, often it is essential to set out what standard of care should be used. And the sort of go-to is a respective standard of care, where the information that you receive or the other party receives should be handled with an equivalent or at least reasonable skill and care. So how you handle your own confidential information should be at least the level that you are providing safety to the information that you receive. Also, the information may not or shall not be used for any other purpose than the purpose defined in the agreement itself. So this is just setting out again the controls over the confidential information, and that it is not used later on, for example, for other purposes and creating new technologies. So here, as discussed, it is to set out the relationship and how to go forward with the relationship, but it is not the agreement itself under which to take the relationship forward. So it is just the first point of contact in that sense. And as mentioned, the restrictions to access. So often these are defined to employees or possibly affiliates. So affiliates meaning affiliate companies, companies connected with the mother company. Advisors, lawyers, consultants, and so forth, and subcontractors as well. So these should be clearly defined, who you can share the information with, what you can do with the information, for how long you can utilize the information, and the actual purpose of what the information will be provided for. So as set out there, as discussed, the NDA itself is just a sort of starting point for the business or other relationship. So here it is good to set out that there's no obligation to take the relationship forward, that it is just an initial point of discussion, and that neither party makes any promises or intentions to make any purchase of products or services or any other commitments. So it is essentially just to evaluate the business relationship. Also, when it comes to intellectual property rights or any confidential information in general, it is good to set out that the other party does not receive any rights to that information that's being provided. So if you are sharing your information regarding, for example, your software, your code, your services that you consider confidential, that the other party receives no right to use it for any other purpose, and that it is only for the purpose under the agreement. So this also gives you control over the information and the intellectual property rights that you might be sharing under the NDA. Then going on to what happens if the contract is breached for any reason. So what's a sanction that could be utilized? Essentially meaning if the other party breaches the agreement, what do they need to pay in essence to cover any issues that breach might cause? So this is often the losses and costs that are involved, whether direct or indirect. It is quite essential to set out whether indirect costs or losses might be involved, as these are quite hard to quantify, and to show that this is an amount that, for example, a loss of profits that this breach has resulted to. So often indirect costs are taken out of the equation, and only direct costs and losses are covered under the sanctions. It is, at least in the past, it has been quite usual to have a fixed amount of liquidated damages. So an amount that at least should be paid if the agreement is breached. Now, what needs to be considered here is that it could become something, especially where you are, as a startup, working with someone who is a big company, corporation, which has a revenue of millions of euros a year, that this could become just a payment ticket for the confidential information you are providing. So it is essential to also set out that if the agreement is breached, then the fixed amount is only the first level, that is the amount that you should receive, and that any damages that can be shown that go above that amount are also covered. And as mentioned, direct damages, these are costs involved with fixing whatever has been breached. And just as a definition, indirect damages are, for example, expenses incurred as a result of the breach, non-performance or lost profits. And as mentioned, these are often excluded. And if taking forward the breach of the agreement, this goes to the dispute resolution process. Often agreements have that disputes are resolved by way of court. Unless then, of course, it might be easier to initially start by negotiating and discussing the breach, and if a result can't be found, then taking the matter to court, where the court will decide the damages to be paid to the other party for that breach. Then going on to the term and termination. So how long the agreement is in effect and for what reason it can be terminated. So essentially, when will the agreement enter into force? Is it when the parties sign the agreement, or is it when the first confidential information is provided, or when you start the discussions under the NDA, or already before the agreement has been set out? So it is good to, especially where it takes some time to sign the NDA, to have it cover also any discussions or any information shared before the agreement has entered into force. Also, the next step is, when can the agreement itself be terminated? So is it enforced perpetually, or is it something that can be terminated with 3 months notice, 6 months notice, 1 month notice? So this is essential so that you have a control over your own contracting process, and that you know how long the contracts you have are in force, and can they be terminated, so that you don't have an NDA from 6 years back, which is still in force today, and might just be a nuisance in the contracting pile. So it is good to have a date for the final termination of the agreement. But this leads on to which clauses survive the termination and for how long. So even though the agreement is terminated, it is advisable that certain clauses survive. For example, the confidentiality obligations and the sanctions, so as to ensure that when the agreement terminates, that the other party can't just begin to use any information for any purpose that they might want, but that the clauses will survive the termination, for example, for 3 or 5 years, to ensure that once that term has sort of come to an end, the information that's been provided under the NDA is no longer viable or something that you would consider confidential, as in the course of the business, you have probably most likely gone forward with matters and the information itself is no longer relevant. Also, what should be done with the information is what should be considered. So will the information, once the agreement terminates, should it be returned to you? Do you want to have that information back, or do you want the other party to destroy that information and any backup copies, or are they allowed to keep the backup copies that are set out when the agreement is the information is sent over? So here it is good to define if the information needs to be returned or not, and in that sense, even if you set out that the other party has to destroy the information, that they have to confirm that it actually has been destroyed, or confirm that they've actually returned all the information that's covered under the agreement, to ensure that you have actually that control over the information, and that if they don't destroy or don't return the information, or they confirm in writing that they actually have, that there is actually a case to take forward after that. Now, coming on to the problems and risks related to NDAs or confidential information itself. So if the information has been set out, it's defined or marked, or whether it's information that it's by its nature to be considered confidential. The problem here is that if it is under the agreement, if it's defined that the confidential information is only information that's defined or marked, you have to always be mindful of the information that you're sharing, so that you're not sharing anything that you shouldn't be sharing with the other party. But then again, if it's information that by its nature should be considered confidential, then even though the parties have come together to set out and both agree on matters, when there is an issue, both parties have their own view of what is information that by its nature should be considered confidential, and this could lead to issues down the line. Also, information known prior by the other party. So going back to the exemptions, this could create issues in the future, as especially if it hasn't been written down or there is no process of where the information has come from. And in the future, you are relying on that information, for example, the other party could see that you're relying on information that's been provided under the NDA and could cause issues in the future for you. So disagreements with the party in question. Furthermore, present and future ideas. Sort of, if you are working in a similar field, it could be quite difficult to show or to justify the need to keep something confidential. How are ideas kept confidential? These can come up from any sort of direction. So ideas themselves are something that can be sort of difficult to define, and these can spring into mind with or after this certain discussions. So this is a risk when sharing information with any other party. So there is a questions, but I think we'll take the questions at the end, so we'll come back to it a bit later. Then, of course, going into control. So the material to be destroyed, for example, that it's actually the material being provided is being used only for the purpose, and so forth. It is quite difficult to verify that the other party is actually doing what you're requesting, but setting out in the agreement the certain terms that need to be complied with to ensure and show that the other party has complied with the terms of the agreement is essential. So here, for example, that there is a written confirmation that the information has been destroyed provides a bit of control over the other party, even after the agreement has terminated. Often then going on to sanctions, often in the negotiation process, this is something that comes up where the sanction amount can be for the other party either too big or something that there's no real reason for it, or that it sort of the sanction is larger than the actual business relationship to be discussed. So this is often a point that comes up for discussion, and that's why it's not a problem, but it is something to keep in mind, that what is the level of the sanction to essentially ensure that the other party won't breach the agreement just for their own business needs, and that they can actually just pay out to take the matter forward. Then going back to the too long or undefined time period for disclosure, so the perpetuality of the NDA, this can just become a nuisance in the end, where you still, as said, an agreement that's still in force after, for example, 10 years, and you are not going forward with a business relationship. So here it's just a matter of ensuring that you have the agreements somewhere archived, and you know which agreements are still in force, and it could just become a bit of a nuisance. And finally, in the negotiation process, the legislation, the governing law of the agreement is something that is often discussed. So which countries' laws will apply to the agreement, and this is often, especially where the trial or if there's a breach and a court case goes forward, it's good to analyze, if you know the legislation involved and you know the court proceedings and the country's sort of courts, it's easier to accept that than something where you have no idea how the agreement will be sort of defined or seen under a certain law. So, for example, when it comes to law firms, we look at the agreements under Finnish law. Hence, where an agreement is under another law, we can't provide information on how it will be defined there. So a counsel in that country would be able to just to ensure that you're not stepping into any mines. So it is good to keep in mind the legislation, the governing law of the agreement before going forward and discuss this, so that you have sort of a backup, for example, legislation or a jurisdiction that is familiar to you, so that you know the process, what would take place if the agreement terminates for some reason. But at this point, I'll jump off and I'll allow Anni to jump on and discuss what happens if you don't have an NDA in place.
Yes, thank you, Juuso. I hope everyone can hear me now. So now if you realize that you have not drafted any NDAs, there are also laws which protect your confidential information, so you probably are still fine. In Finland, we have this Trade Secrets Act, which provides the basic level of protection for your confidential information, and it has entered into force in 2018, so it's rather new legislation. And it is mandatory legislation, so it applies to your business relationships, even though you have not agreed on that separately. And it has been implemented based on the EU Trade Secrets Directive. So because it's based on the EU directive, the directive provides the basic level of protection throughout the European Union, although there might be some variations from nation to nation. And the most important thing on the Trade Secrets Act is that your confidential information has to fulfill the criteria set forth in the Act in order to be protected. So it does not protect everything. And the requirements are that the information must not be generally known to persons that normally deal with such information. And also the information has to have some value to your business activities. And in addition, the trade secret holder has to take some reasonable steps to keep the information secret, so you cannot go showing your trade secrets to everyone. And the Act prohibits unlawful acquisition, use, and disclosure of the confidential information. There are some exceptions. For example, independent discovery and then reverse engineering of a product that you have acquired lawfully. Those are permitted. And the Trade Secrets Act provides some civil remedies in cases of trade secret misappropriation, for example, injunctions, or you can claim that the goods which infringe your trade secrets are withdrawn from the market, and you can also receive compensation or damages. And then finally, you can switch to, yes, we have a case study example which demonstrates the importance of protecting your confidential information. So if you haven't heard, the RESQ Club app is an application aimed to reduce restaurant food waste. So through the app, you can buy leftover restaurant food so that the food does not go to waste. And when the app was launched, it received praise that the idea is really clever and useful. But actually, the founder of the RESQ app had copied the concept and idea from another company called Lunchy, who originally created the concept. So the founder of the RESQ app had worked for Lunchy, but then he was kicked out because they have some ideological differences. But before he left the Lunchy company, he copied all the necessary information to build his own app based on the similar or the same idea and concept. And because the founder of the RESQ app had not signed any NDAs, he was claiming that he did not breach any contracts, and it was okay for him to do that. But because the Trade Secret Act is mandatory legislation, it governed the information disclosure even though there was no NDA in place. And the RESQ app founder was actually found guilty of infringing and abusing trade secrets, and he was sentenced to probation. And this RESQ case was very clear because he had copied the whole idea and concept. But in some cases, it could be harder to prove that there were actually activities that violated the Trade Secrets Act. So thus entering into an NDA is probably providing more secure and predictable protection for your confidential information.
All right, we have come to the end of our webinar. Just as a summary, when it comes to any business relationship, initially it is advisable to, before going forward to set out an NDA, to be able to discuss with more ease on the possibilities and where you want to take the business relationship. But if this is something that you forget to do, or it is not in your process, or you don't have a template yet, when it comes to the actual agreement itself, do remember to set out the non-disclosure or confidentiality obligations in the agreement itself. And that is something that needs to then also cover anything that's been discussed before when it comes to the business relationship involved, so that it is clear to both parties that what information is to be kept confidential and what can be utilized even when the business relationship goes forward. Also, just as a general reminder, the NDA is there just to begin discussions and shouldn't be the actual agreement that you're relying on to take the business relationship forward. So once the NDA has sort of fulfilled its purpose, the next step is to set out an actual agreement on which the business relationship should be based. But that brings us to an end. If you have any questions, this is a good moment. You can pop them in the Q&A or in the chat box, and we can answer. And if there aren't, we'll wait for a few minutes still before closing. So Anni, if you keep an eye on the questions and answers, and I'll
yes.
the chat box. All right. Doesn't seem that anybody is writing anything, so I guess we can bring this webinar to an end. Thank you on my part for everyone who's been listening. If you have any questions regarding NDAs or agreements or confidentiality, do reach out to us here at Lexia or through our growth website, and we will be able to answer your questions and help you out in the future with these matters, or any other legal matter that you might need assistance or a bit of sparring with. So I guess thank you on my part, and we will be sending out the information that we've shared today to you in the future, and I guess within the next 2 weeks, as well as then these will be published on the growth website and YouTube. And yes, here answering, I guess, the question that came up. So all attendees will receive this information, as well as then an email which will tell about the next topic in the future for the growth webinars. So yes, thank you on my part, and have a great rest of the day.
Thank you for listening.